The following legal observations were made by George Lujack, former New York City police officer, regarding the legal proceedings in the government's trial against Kent Hovind and Paul Hansen. The evidence submitted in the criminal case against Kent Hovind and Paul Hansen does not meet the legal prima facie standard that requires a criminal case to exist and go forth. Therefore, the whole trial should be thrown out as having insufficient evidence to proceed. The term prima facie, pronounced prima facie, is used in modern legal English, including both civil law and criminal law, to signify that upon initial examination, sufficient corroborating evidence appears to exist to support a case. In common law, jurisdiction prima facie denotes evidence that, unless rebutted, would be sufficient to prove a particular proposition or fact. Most legal proceedings in most jurisdictions require a prima facie case to exist, following which proceedings may then commence to test it and create a ruling. In many court proceedings, the defense often objects to evidence being submitted on grounds that it does not meet the prima facie standard and is unrelated to the crime. The government's prosecution team against Kent Hovind and Paul Hansen are being allowed to submit, according to the court docket, 127 articles of evidence that do not meet the prima facie standard. The primary charges against Hovind and Hansen are mail fraud. Of all the documents presented as evidence, there was nothing at all being presented as fraudulent documents, nor has the prosecution made the argument that any documents, evidence submitted contains fraudulent statements or representations by the defense. An example of evidence being excluded by not meeting the prima facie standard. A husband reports that he came home and found his wife stabbed to death. Investigators suspect the husband is the murder suspect and have him arrested and brought to trial. There is no murder weapon presented at trial, as this was not recovered by the prosecution. However, the husband was a knife collector, and in his garage he collected a collection of 120 knives. The prosecution wants to present all 120 knives as evidence that the husband was a knife buff, and show that he surely knew how to use a knife and would likely have used a knife as a murder weapon of choice. The knives were dusty and were obviously not used in the murder of the man's wife. The defense and/or judge should not allow the prosecution to enter in 120 exhibits of knives as evidence that the husband murdered his wife, because these particular knives are not meet the prima facie standard to be presented as evidence in the courtroom. But these type of non-prima facie standard documents have been allowed to be entered by the prosecution team in the case against Kent Hovind and Paul Hansen. There has been no document presented that can be said to establish fraud, intention fraud, or otherwise. Many of the documents presented by the prosecution were signed by Paul Hansen and notarized. The prosecution made a peculiar ploy by bringing in all the notaries to testify, having them explain that while they notarized the documents, they merely authenticated that the signee, Paul Hansen, was actually him. They did not review the documents as being legitimate or lawful. The prosecution was attempting to say by neglect or implication that because the notaries did not authenticate the documents themselves, but merely verified the person signing them, that it was possible that the documents could have been fraudulent. However, the prosecution never presented any evidence whatsoever that the documents were indeed fraudulent. None. Therefore, the conversations between Hovand, Hansen, and others could not be considered conspiracy to commit mail fraud, but rightly regarded and discussions of how to appeal the court's prior rulings and judgment. Therefore, if there is no fraud, there can be no conspiracy to commit fraud. An honest judge would throw out the case based on the fact that none of the evidence meets the prima facie standard to establish fraud. The prosecution being allowed to present non-prima facie standard documents and conversations as evidence is allowing them to present a mountain of court documents, legal findings, conversations, etc., that are unrelated and do not meet the criteria to establish the actual charge of mail fraud. The purpose of presenting this mountain of non-prima facie evidence is undoubtedly to present a parade of horribles in order to confuse and trick the jury into believing that since there is so much evidence, quote unquote, presented, that Kent Hovind and Paul Hansen must be guilty of something. Furthermore, some of the evidence presented were court documents signed by Judge Rogers herself, who is the presiding judge in the Hovand-Hansen current case and who was the presiding judge in Kent Hovind's original case. Therefore, Judge Rogers is ruling on a case in which she herself is a participant through her signed documents, and she is ruling on a case in which she previously ruled the defendant in her prior sentencing statement as the head of an extensive criminal operation, or words to that effect, but I think that's the proper quotation. The defense asked her to recuse herself in this current trial with the understanding and belief that she not remain unbiased in her judgment rulings and possible sentencing. Judge Rogers has refused to recuse herself even though she is an active participant in this current case, and it is believed, based on her prior statements, that she cannot remain unbiased. Based on the court atmosphere thus far, Judge Rogers has offered to buy the jurors lunch as to not be disrupted by protesters outside the courtroom and to shield them from information on jury nullification and other aspects of the case. Judge Rogers has also not allowed the public to take notes in her courtroom, making it difficult for people to report on the proceedings in the case. As for the charge of criminal contempt of court, the application of the law is being extended in the Hovand-Hansen case. The prosecution is attempting to make the case that an appeal or protest of a court ruling amounts to contempt of court. The purpose of criminal contempt is to force defendants to comply with orders of the court during a trial, usually for the purpose of producing evidence that a defendant is believed to have but is withholding from the court, or for a defendant to act properly in the courtroom. Criminal contempt was not enacted into law for courts to be able to charge people with criminal contempt for either appealing a court's ruling or for appealing a court's judgment. In the Hovand-Hansen case, the court is making the leap in saying that because Hovind and Hansen filed a lis pendens, which is legal documents informing the public that there is pending litigation of the property that the government seized from Creation Science Ministries and was selling, they are in effect in contempt of court. Filing legal notices of pending litigation, appeal objections to court rulings or judgments are not actions that amount to criminal contempt of court. If it were so, then any time a judge made a ruling in any case and that ruling was appealed, then whoever makes the appeal and whoever is represented in the appeal would be guilty of criminal contempt of court. This whole trial stinks of persecution, corruption, a perversion of justice, and due process. Deuteronomy 16:18 through 19. You shall appoint judges, and they shall judge the people with just judgment. You shall not pervert justice. In Jesus Christ, the Messiah, George Lujack.